The parcel was jointly owned by two families, John Garrett and his brother, Herbert, and his wife, Mary Garrett. Herbert dies in 1965. His wife, Mary, assumes ownership of the surface and the oil and gas of that 1/2 interest. Sometime later in 1977, she sells the surface to the heirs of John Garrett. She keeps oil and gas, but sells the surface to the other family members. Not uncommon, happens frequently here in Pennsylvania. Sometime later, the John Garrett heirs, they sell their 1/2 oil and gas interest to some guy named Anderson. Anderson then enters into an oil and gas lease with Northwood in 1989. Under that 1989 lease, Northwood and or its predecessor actually drilled two wells, two shallow wells, to about 2,400 feet. Sometime later in 2013, the heirs of Mary entered into their own oil and gas lease with Gulfport. As you can imagine, there was some disagreements as to who owned what, and Northwood eventually says, next slide, please. Next slide, Brendan. There we go. Back one. There we go. Northwood, in order to avoid litigation with Gulfport, says to Tomchenko, who acquired the property from Anderson, hey, I'm not going to pay you the full royalty amount anymore because of this 1977 reservation. You only own 1/2. In 2016, Tomchenko files suit and says, no, the heirs of Mary don't own anything because I and my predecessor, Anderson, acquired all the oil and gas rights via adverse possession. Next slide. The trial court partially agreed with Tomchenko and said, because Mary's heirs never challenged or contested the 1989 lease, Tomchenko acquired their 1/2 interest down to the deepest depth of those shallow wells, 2,414 feet. Trial court said, but as to the deep rights, Mary's heirs still own those because there was never any actual possession and drilling of the deeper formations. Therefore, adverse possession wouldn't apply. Next slide. Next slide. Okay. On appeal, Tomchenko argued that the 1989 lease covered all the hydrocarbon formations. He argued, look, there was no depth severance in that lease. It applied to from the surface to all formations, and therefore, when I entered into that lease, I essentially was possessing all the hydrocarbon formations. Ironically and critically, the 7th Appellate District agreed with Tomchenko and reversed the trial court and held that the 1989 lease, as well as the actions in drilling those two shallow wells, effectively possessed all the hydrocarbon formations, including the deep shale. This decision is problematic for landowners for a couple of reasons. Number one, typically mere leasing of the oil and gas rights is not enough to establish possession. And adverse possession as a legal concept, it requires the party asserting adverse possession to have actual, adverse, and hostile possession of some piece of property. And in the oil and gas world, that element of adverse possession typically means you actually have to drill and extract hydrocarbons in order to be in possession of that property interest. So along that same corollary, mere leasing is generally not enough. So the authors, Brendan and I, we believe that Tomchenko, the 7th Appellate District, got it wrong when it gave weight to the fact that the 1989 lease applied to all formations. That's not the correct analysis, and the court erred to the extent that was the basis for its opinion. Secondly, the 7th Appellate District made a big deal about the fact that these two shallow wells somehow impacted and altered the deeper hydrocarbon formations. It never explains how, in its opinion, but it assumes that these wells, even though they were only down to 2,414 feet, they changed the subterranean features of the deeper shale formations. I'm not a geologist, but that doesn't even make sense. Shale formations are of low permeability. They have to be perforated and then hydraulically stimulated in order to induce flow. The fact that there was two shallow wells several thousand feet above the shale formation you can't give credence to the argument that somehow those shallow wells impacted the shale formations and therefore that constituted possession. It just doesn't make sense. And again, Brendan and I would say that that was an erroneous assumption that the court made. Finally, one of the elements of adverse possession is that you have to have actual possession and drilling. And I know that I've already said that several times, but even in the context of this case, the court overlooked the fact that there was never any drilling below 2,414 feet. If that element's going to mean something and you have to have actual possession and drilling, well, then you can't just assume that a shallow wellbore of 2,414 feet constituted possession of all hydrocarbon formations. The example that when I read this case, what I thought was, well, what does this mean? Can a surface owner drill a water well 75 feet in depth and operate that water well for 21 years and then suddenly argue and contend that he has acquired all the hydrocarbon formations because he drilled a water well. He drilled a well down to a certain depth, and that may have altered or impacted the deeper shale formations. Therefore, he now owns everything through adverse possession. I know that's an extreme example, but when you test the viability of an argument, you have to push it to its logical conclusion. And here, I use the water well example as illuminating why the Tomchenko decision was wrongly decided and is a troubling decision for landowners. Again, it's an Ohio decision, so it's not binding on Pennsylvania courts, but we have to be wary of other oil and gas jurisdictions because sometimes the rationale and logic of these decisions, even if they're flawed, make their way into Pennsylvania. So if you're a owner of the subsurface and you don't own the surface, be wary of the surface owner trying to make efforts to drill some type of well to acquire oil and gas rights that are much deeper and unrelated to the well that was drilled. So that was our first case. Again, if you have questions or comments, please hold them to the end and we'll try to get to them as best we can. The next case we want to talk about is SLT Holdings versus Mitchell Energy, a significant case from the Pennsylvania Supreme Court, and my colleague and friend Brendan is going to address this case. Brendan?
Thank you. So this is the second presentation where an SLT Holdings decision has come up. The first time was about a year and a half ago, I believe, and it was the Pennsylvania Superior Court's decision. This is an interesting case, not only because of its decision, but ultimately why this case got so far. So we'll go over some basic facts here because it's one of those situations where as a landowner or a landowner's attorney, kind of scratch your head and say, this should be a slam dunk. This case should not have dragged along and gone as far as it did. So this case is out of Warren County, about 1,500 acres under two separate leases signed in 1985. The leases were identical. One lease was on there were two parcels involved, one lease on each parcel. Two shallow wells, oil wells, were drilled, one on each parcel. They produced oil for a bit of time. The primary term had ended. They continued to produce, but they stopped production in the mid-1990s. In 2013, the landowner filed an action in court under a variety of different theories, ultimately seeking an adjudication that the 1985 leases had terminated. There was ample evidence in the record that essentially the operator had just walked away. The wells were in poor condition, no oil had been produced, no additional wells had been drilled, no money had been paid. There was not electric, there were no motors. to operate the wells. It was a summary judgment matter. The landowner moved for summary judgment, and the trial court agreed on the basis that the leases and leaseholds had been abandoned. It was appealed to the Pennsylvania Superior Court, which essentially affirmed the rationale of the trial court in 2019, finding that the lessee, the driller, had abandoned the 1985 leases. From there, the Pennsylvania Supreme Court actually accepted the matter for consideration. It was a discretionary review. The Pennsylvania Supreme Court did not have to take the case. And frankly, we were a bit surprised that it decided to take this case because, like I said, the facts were so out there. 16 years of non-production, no payments, a leasehold just in disarray. You say to yourself, well, if that doesn't end a lease in Pennsylvania, what does? So the Pennsylvania Supreme Court actually said that it wanted the parties to discuss the issue of producing and paying quantities under the Jedlicka standard from about a decade ago. But it also wanted the parties to address the issue of abandonment, which is what the trial court found upon, what the Superior Court found upon. On April 29th, about 2.5 months ago, the Supreme Court reversed the Superior Court. The Supreme Court put a lot of weight into a default provision in the leases, in its paragraph 12. And basically the default provision in these leases said that if the drillers were in default of an obligation under the lease, the landowner had to provide notice, and there was an opportunity for the driller to cure or to resolve the issue. And if it failed to do that, and a court had determined that the default had not been cured or remedied, the sole remedy for the landowner was a termination of the lease. And that is a provision that the court put a lot of weight into. And essentially, the Supreme Court concluded that the trial court and the Superior Court had skipped a step, that they had overlooked the remedy in paragraph number 12 of the lease. Now, this is problematic for a variety of reasons. It's not on here, but I would submit that an overarching question here is how does this case fit in to Pennsylvania oil and gas law? It's not that old. The first case we discussed was from Ohio. And like Bob said, you have to look at other jurisdictions and the reasoning to see how it affects Pennsylvania. But this is a Pennsylvania Supreme Court decision. It's the highest court in Pennsylvania. So you always try to figure out, okay, where's the court going? What's it looking for? And a big question that we have here relates to the treatment that the court gave to the case in general. What approach did it take? And when you read the decision, it almost makes it look like the court was, if you use a football analogy, throwing a flag on the field, which nullified a touchdown, which would be the landowner winning. And it said, look, the courts did not follow the proper procedure. They got to the issue of abandonment without looking to the actual remedy in the lease. You couldn't do that. You have to go back and do it again. So the court didn't say the landowner lost. So the court didn't say they couldn't win, score a touchdown on the next play. The court didn't say the landowner couldn't win the game. They just said what happened here was against the rules. Try it again under a different process. So it seems that the court focused a lot of its attention on that procedural matter, throwing the flag and saying abandonment, we can't get to abandonment if we look at the contract and there's a remedy in the contract. But that is difficult to take because, yes, oil and gas leases are contracts, but they're also transfers of real property interest. And we have what's called the automatic termination rule. When a driller starts to produce oil and gas and you're beyond the primary term, the driller has what's called a fee simple determinable interest in the oil and gas, which means as long as they satisfy the lease, they have the rights to the oil and gas. But when they no longer satisfy the lease, that interest automatically terminates. Landowner doesn't have to do anything. It automatically terminates. So in this particular situation, the facts seem that there was a fee simple determinable vested in the driller, and that when termination ended and there were no payments, like shut-in payments or anything like that, the automatic termination rule should have kicked in and nullified any rights under the lease. So there is no discussion of the automatic termination rule, which is a head scratcher, because on one hand you say, well, you need to discuss that. So is the court saying the automatic termination rule is no longer the law in Pennsylvania? It didn't say that. We would submit that the court seemed too focused on the contractual duty or obligation, which is the second part, which is another confusing point. Under these leases, in this case, any other lease, production generally is not an obligation or a duty. It's something the driller can do. It's something the driller must do to keep its lease rights alive, but it's not something it's forced and compelled to do. So if the court is looking at a default provision where it says if the driller has defaulted on an obligation, you have to find an obligation. And the only obligation here would be to either produce oil and gas or to make a payment in lieu of production. But here it seems that the driller just completely walked away. So we would submit a payment, a shut-in payment, is not going to carry the day when there's no motor or electricity to even pump wells. So it's confusing in this regard too, because you say, well, is the Supreme Court radically changing the law to say that drillers are under affirmative duties to produce oil and gas? Or again, is the court just looking at a contractual remedy as if it would be looking at an insurance contract and saying, wait, let's just take a look at what the contract says and what the parties agreed to? But again, there are larger overarching issues here that should keep you away from just a strictly contractual interpretation, require a larger question about what is the nature of the rights that the oil and gas interest owner has. And that brings us to the third point here. Under the default provision in these leases, it provided time for the driller to cure or to resolve the issue. So if you think about if someone doesn't pay you money and you have to write them a letter before you go to court and say, look, you haven't sent me rent checks for 4 months. Please do so within 30 days or I'm going to file suit. Money can be paid. But in the case of 16 years of non-production of oil and gas, this isn't back to the future. You can't go back in time and start producing. There is no cure that can be had. And that is something the court didn't pick up on in its decision. It to some degree assumed that there could be a cure that would make the default provision make sense. But the default provision doesn't make sense if there's not a default that someone can actually fix. And because the automatic termination rule would kick in, you can't revive the lease. The lease is over. A decade and a half of non-production, you can't change it. So it's almost that the court assumed that something could be done without describing when, where, and why that could actually happen. So the takeaway from SLT is, again, like I said, it's unsettled. You have to see what this actually plays a role in going forward. Is it just a decision that goes off to the side, or is it a principal decision? One thing that it does is it seems to make clear that the question of abandonment as a legal doctrine is pretty much at the bottom of the list. The court focuses on the existence of a contractual remedy and says if there is a remedy in your contract, you can't get to the question of abandonment. But a corollary to that is a question where the court says, if there is a remedy at law, you can't go to abandonment, which it calls an equitable remedy. Equity is essentially the end of the road. If there's no legal remedy, you get to the equitable remedy of abandonment. But a question on that front relates to a quiet title action. A quiet title action, which many landowners are familiar with, is an action at law. And it's frequently used by landowners for an adjudication of whether a lease is valid. So a question is, if there is a remedy at law, for example, a quiet title action be commenced, does that mean abandonment really would never have a role at all? The court doesn't get into that because, again, it focuses just on the contractual remedy, but it doesn't broaden it out to a larger discussion of issues. So that's where you have to see how this evolves. But it's certainly something that landowners should be aware of on a couple fronts. Number one, there is no slam dunk lease termination case. 16 years of non-production, non-payment gets you to the Pennsylvania Supreme Court, only to go back to the Court of Common Pleas to do it again. Abandonment, maybe that issue's been resolved to some degree, but not fully. And a general rule or a thought for practitioners is to always make sure that there's a contractual issue, and then there's the real property issue that are there. Because even when you get to the Pennsylvania Supreme Court, you can't necessarily assume that they will look at the entirety of the angles. That it's important to present, yes, this is a contract, but there are real property interests at play here. So we have to see how this one shakes out, and we'll also have to wait to see how the Jedlicka good faith producing and paying quantities issue gets resolved in some case in the future, because that was something the court wanted to discuss here, and it never did. And quite frankly, I think that's a lot more interesting issue and pressing question for oil and gas owners than the ultimate question they got to here, which was really just throwing a flag out on the field and saying, go back and try it again under a different theory. So a lot of questions from SLT. We'll see how it plays, but I think we can be rest assured that oil and gas companies will try to interpret it as broadly as possible. So if your lease has a default provision in it, absolutely be aware of it and expect drillers to kind of parrot the language from the Supreme Court that is the only remedy that you have, that nothing else is in play if you believe that your lease is no longer operative. Bob?
Thanks, Brendan. My concern, as you and I have talked many times about SLT Holdings, is the Supreme Court just didn't seem to grasp the distinction between the property interest created by an oil and gas lease and contractual remedies that may exist in that lease for contractual obligations. Production and maintaining the lease beyond its primary term is not a contractual obligation. It's what's needed to preserve and maintain a property interest. And the court just never quite got it. And now we're left with the decision that is troubling and ambiguous for landowners. Nonetheless, we're going to now pivot slightly from the lease ownership, lease expiration type claims to some royalty litigation. We have 4 cases that we want to talk about. Again, a lot to cover, but we're kind of going to give you the high altitude on some of these cases. The first one is Quarter versus Antero Resources. And this is a recent case from the Northern District of West Virginia. Again, not binding on Pennsylvania courts, but I do think it's instructive of where the courts are going with this type of an issue. At issue in Quarter was essentially a number of leases were being disputed. The parties entered into a settlement agreement whereby they characterized the royalties to be paid as gross royalties, and that there would be no market enhancement, no post-production costs, except as per a market enhancement clause that was going to be amended to a number of these leases. Well, the plaintiffs, the landowners, started to get royalty statements, and they saw all these processing costs being deducted with respect to the NGLs, natural gas liquids, that were being produced. And the landowner argued that, hey, wait a minute, we settled what this lease language was supposed to be about, and I agreed that I wanted a gross royalty on some of these leases, or a market enhancement clause was going to be amended to these other leases. You can't deduct these costs because the gas itself is not marketable until it's processed. It can't go into an interstate pipeline until you remove the heavier hydrocarbons, the NGLs. The BTU content is simply too high. You can't get it into the pipeline until you take out the NGLs. Therefore, the processing costs are not deductible. Next slide. Antero disputed the landowner's interpretation and argued that, well, no, the market enhancement clause allows us to deduct these costs because what we're doing here is simply enhancing the raw gas. We could sell the raw gas at the wellhead, and what we're doing is therefore enhancing the value of that gas, that raw gas stream, by moving the gas down to a processing facility, extracting the hydrocarbons into separate, the heavier hydrocarbons into separate products, selling those products, and then also selling the residue gas. So everything we're doing downstream from the wellhead is essentially an enhancement. And Brendan and I have seen this argument many times, that drillers take the position that anything they do downstream from the wellhead is an enhancement. You know, moving the gas 50 feet, hey, we enhance the value. And Antero is making the similar argument here that we could have sold the gas at the wellhead, all the hydrocarbons bundled into the unprocessed gas. Someone would have bought it. They wouldn't have paid very much because of all the costs that would be required to refine and process that gas. But we could have sold it to someone. Someone would have paid $1 for it. Therefore, it's marketable. That argument, in theory, has always troubled me because it doesn't reflect reality. Who was going to buy all this unprocessed gas at the wellhead? No one. People were only the potential buyers for that gas were not going to buy the gas and then have to build their own gathering system and processing facility in order to move it further downstream to the interstate marketplace. Next slide. The court ultimately determined that Antero's interpretation and application of the market enhancement clause did not satisfy the three-part test set forth in two cases in West Virginia, Wellman and Tawney. And again, West Virginia is a marketable product jurisdiction. It's somewhat different than Pennsylvania, but I do believe Pennsylvania is moving in a marketable product direction because I think it makes sense. You know, all oil and gas jurisdictions recognize the implied covenant to market gas. And that typically means you have to sell the gas. You can't just drill a well and let it sit there for 5 years, 7 years, 8 years. You got to make some effort to actually produce and sell gas. Number two, you have an obligation to go out there and get the highest and best price for the gas. You can't just sell it to your buddy for 15 cents. You got to actually take some effort and due diligence and sell it at the highest and best price. Well, some jurisdictions like West Virginia, Colorado, Kansas, they recognize that there's a third element to the implied covenant, that the driller has an obligation to actually market the gas and put it into a marketable form. The landowner doesn't have the ability to do that, or the expertise or the experience. Only the driller does. And the implied covenant, if we're going to read that covenant into a lease, well, then it makes sense to also include an obligation to transform that raw, unprocessed gas into a marketable product and then sell it from there. So that's the marketable product rule. But I believe Pennsylvania is moving in that direction. If you look at some of the other court cases and some of the litigation position that the drillers are taking, I believe they're starting to recognize that, look, there is some obligation to move the gas to a place where it can be sold and in a condition where it can be sold. And that location is the interstate pipeline network. That's where the majority of your gas is marketed and sold, and therefore it's not really in a marketable condition until it is there. Anyways, back to Corder. The district court ruled that this did not satisfy the Tawney test. And one of the elements of the Tawney test was that in order for post-production costs to be deductible under West Virginia's interpretation of the implied covenant rule, the lease has to spell out with specificity exactly what costs are going to be deducted. And this lease, according to the district court, did not satisfy that prong of the Tawney test because it did not identify whether NGLs were quote unquote an other product under that clause. The actual clause had language that said that the royalty was to be without deduction of any cost incurred to transform the oil, gas, and other products produced hereunder into marketable form. And the court said, under West Virginia law, we need specificity. And because there's an ambiguity of whether the NGLs are a other product, we're going to rule in favor of the landowner and hold that the processing costs are not deductible. The other thing the court said was the lease was silent as to what exactly needed to be done to turn gas, transform the gas into marketable form. And I thought that was significant, that we finally had a court that said it has to be spelled out, or there has to be some direction in the lease identifying where and when the gas is in marketable form. We're not just going to accept the driller's word that it's marketable here because we say so. The court suggested, at least implicitly, that we're going to require more. And that is a positive sign for landowners, that a federal court did not just accept hook, line, and sinker, that the driller was saying the gas is marketable here just because they think it is. In sum, quarter represents the ongoing battle in a lot of these cases between what is an enhancement cost and what is a cost that is incurred to transform the gas into marketable form. And Brendan and I have litigated a number of these cases. I think this is the trend, that courts are now starting to look at where exactly is gas in marketable form, and they're applying a perhaps more scrutiny to where in that linear approach is the gas actually in marketable form. Not at the wellhead, because number one, you got to process it to remove the heavier hydrocarbons to lower that BTU content. And number two, there is really no market to buy gas at the wellhead. You might find an outlier where someone's willing to buy the gas at the wellhead, but then it creates tension with the other element of the implied covenant to market, which is the driller's under some obligation to get the highest and best price. And selling it to someone at the wellhead just so you can start taking deductions or make the argument that all the other gas you sell is marketable, I think runs contrary to the implied covenant to market gas, which is for the best interest of the landowner. So quarter, again, it's West Virginia. I think it's a well-reasoned opinion on this aspect. It's not binding on Pennsylvania, but perhaps it reflects a growing trend of courts paying much more attention to where gas is in marketable form and where the marketplace is for the shale gas. Brendan, you want to take the next case?
So the next case is Bpx Operating Company versus Strickhouse. This was a fairly recent decision in the last couple of weeks from the Texas Supreme Court, and it is a bit of a different flavor than quarter. This relates to royalties, but in a different fashion, and it's probably best described as a royalty and a unitization issue. So this focused on a 2009 lease. The Strickhouse had a lease, owned part of a property. Another landowner owned the other half of the property. They each had leases, and this one concerned Strickhouse's lease. And the lease explicitly says in the pooling provision that pooling cannot be done without the express written consent of the landowner. And there is also a provision in there that it could not be forcibly pooled under Texas law either. So one could say that the lease was absolutely clear that express written consent of the landowner was needed for any pooling or unitization of the property. But as things happen, the property interest was included into a pool by Bpx. No written consent was obtained, and a horizontal well was actually drilled under the parcel. So we have a contract. The contract was not followed, and the landowner got an attorney who reached out to Bpx and basically said, what's going on? You know, justify your conduct. It seems that you put us in a unit. Please show us the legal authority for doing so. A lot of back and forth. Bpx eventually said, yeah, you know, we didn't get your express written consent to throw you in a unit. And the landowner's attorney made no dispute that they were, you know, challenging the propriety of the unitization. Settlement proposals came back and forth. The landowner's attorney made clear that they, you know, were not going to just roll over and ratify the unitization as Bpx had wanted. They had sent essentially a ratification of the pooling agreement, said, hey, sign this. because we already drilled under your property. The landowner's attorney asked questions such as, how would we get paid and how much would we get paid if we do not sign off on the unitization versus if we get paid out of the unit. And at the end of the day, a settlement proposal was made by the landowner, and Bpx did not accept it, but royalties had been tendered, and the landowner accepted them and deposited them in February of 2013 for about $250,000. In 2014, the landowner filed suit alleging that there was a breach of the pooling clause because the property was undoubtedly pooled without the express written consent that was required by the lease. Royalty payments continue to be made by Bpx associated with the well, and it went to about $700,000. The landowner continued to deposit those funds during the course of this dispute. And Bpx argued in the trial court that the landowner's acceptance and deposit of the royalty checks, $700,000 or so of production royalties, functioned as what they called an implied ratification of the unauthorized pooling. Essentially, look, we know what the contract says. We know that the contract, we did not follow it. But the fact that we didn't follow the contract doesn't matter anymore, because the landowner's acceptance of royalties means that they don't have standing or a basis to challenge what we've done. They've said, essentially through their conduct, what we've done is okay, even though we didn't follow the contract. The trial court agreed and said that the landowner had ratified Bpx's conduct in its unlawful unitization by accepting the royalty checks that came from the well in the pooled unit. Obviously, that was concerning and troubling to landowners, and the landowner here appealed that to the Texas Court of Appeals, which reversed the trial court. And it said, look, the landowner never expressly ratified the unit. Bpx had offered a ratification of it, but the landowner had never agreed. So the trial court got it wrong. The matter was appealed to the Texas Supreme Court. And there is a note in the Court of Appeals too, that this wasn't a situation where the landowner was owed something or nothing. It was the question of whether they would get paid 25% versus 23.7%. And those figures come from the interactions between Bpx and the landowner's attorney in the negotiation to say, how much would I get paid if I ratify this versus if I don't? And the position was, well, if you're in the unit, you get paid based on your participation in the unit. If you're not, you get paid based on the producing length of the horizontal well beneath your property. So it was a very slim margin of what would be paid, but it was a question of whether the contract had allowed it or not. And the fact that some money was owed, I think, was an important part of the Court of Appeals reasoning here that goes into the ratification question. And the Supreme Court of Texas agreed with the Court of Appeals that there was no implied ratification just by the acceptance of royalties by the landowner. The Supreme Court did not accept the Bpx argument that cashing a check automatically meant that you ratified everything that happened. Instead, the court said, look, you have to look at everything in context, see everything that was going on to determine whether there was an intention to ratify. And here, there were ample communications between Bpx and the landowner and their attorney. Those communications made it clear that Bpx had not followed the contract, that the landowner was not going to ratify what was done absent some kind of settlement. And when you take all of that in context, you have to see that the landowner was not just simply saying, look, whatever you've done, it violates the contract, but I'm okay with it. Instead, when you look at it more broadly, you see that the contract said something, the unitization was done, the well was drilled, the hydrocarbons were produced and sold, they're never coming back. Either door number one or door number two, the landowner is owed something. So the mere act of depositing money that was owed to the landowner, it makes sense that that cannot function as a ratification of the lease. This is something that is frequently encountered by landowners in Pennsylvania, and it is reasoning that should again be transportable to Pennsylvania. Now, we make it clear this is a Texas case, so it's not binding on Pennsylvania courts, but the rationale makes sense. Look at the totality of the circumstances. Look at the party's intent, and trying to distill things to one yes or no question. Did you cash the check or not? Is an unnecessarily limiting view of a ratification. And it is something that drillers have tried in Pennsylvania. It is something that we highlighted in an article a couple of years ago when the General Assembly amended the law associated with royalties. And it basically said, look, if you haven't paid in a while, if you make a payment, you write in there, that you are, making this payment for what was not paid in the past, then depositing it, could be a ratification of past conduct. This makes a lot more sense. It's not advised to simply deposit checks. It's necessary to interact with counsel, and that's what the landowner here did. Interacted with counsel. The attorney worked with the gas company to make the position clear. But it shouldn't be a penalty to deposit money that you're owed, so long as you make your intentions clear to the gas company that you are not ratifying the conduct. And that's one of the features too that should not be overlooked. It can't just simply be, look, I was depositing the checks, but in my head, I was disagreeing with it. You have to make that position clear to the other side. And that's where the Texas Supreme Court looked to the totality of the circumstances. Just looking at the driller's perspective or the landowner's perspective is not the way to go. You look at the extent of the interactions between all sides to really determine what anyone was doing to see whether there was the intention to ratify or not. And in this particular case, it was in the landowner's favor. And it seemed like a well-reasoned decision because all the other circumstances made it pretty clear there was not an intent to ratify the admitted breach of the contract by the gas company.
Thank you, Brendan. I think BPX is a well-reasoned opinion, and I think it, by analogy, we can use it here in Pennsylvania, that if you have a landowner who is disputing a pooling issue, the unitization of a lease, and the question is, did you pay me, is my decimal interest being properly calculated? The fact that you're getting royalties, as long as you interpose that objection, I don't think the acceptance of those royalties checks is going to operate as an implied ratification. You and I have argued that many times. BPX versus Strickhouse seems to support the position we have taken in the past. And I think it's a well-reasoned opinion. Next slide. We're already starting to run out of time, so I'm going to try to move things along, try to cover these last two cases. The next one is Coastal Resources versus Chevron USA. This was a case that was decided in early May. It's from the Western District of Pennsylvania. So it is a Pennsylvania case, unlike some of the others we've talked about so far. It does have a little bit more value and weight here in Pennsylvania because it was a federal district court here in Pittsburgh that rendered the decision. Is it binding on Pennsylvania state courts? No, but in federal district courts, this decision could have some precedential or persuasive value. So we want to take a close look at Coastal Resources. At issue was a 2007 lease concerning about 350 acres in Greene County. The royalty clause provided for 15.62% of the gross sales price received by the lessee. And then it had some language at the end, thereof at the wellhead. As you could imagine, the landowner read this clause to say, hey, gross sales price, hey, that means no deductions. Gross sales price, that's what my royalty should be based on. They got their first royalty statement in April of 2020. There was $53,000 in deductions. So they challenged it last summer and filed a suit against Chevron alleging a breach of the royalty clause. Next slide. Chevron filed a motion to dismiss and argued that the mere presence of the phrase "at the wellhead" automatically authorized the netback method. And as many of in the audience might be familiar, the netback method is a process by which a driller nets out costs that are incurred between the wellhead and the actual point of sale. And every driller in Pennsylvania, and Brendan and I run into this every day, they defend almost every deduction claim by pointing to Kilmer. And they say, Kilmer allows us to take deductions. And they kind of view Kilmer as this universal rule that amended and changed every oil and gas lease, regardless of the language in the particular lease. And Kilmer was a Pennsylvania Supreme Court decision. In that particular lease, the royalty clause did allow for the deduction of post-production costs, but the landowner challenged that the deductions were unauthorized and were not expressly permitted. The court ultimately said, no, you can use the netback method to arrive at a wellhead value when the lease says the royalty is to be valued at the wellhead. Now, Chevron's entire position focused only on at the wellhead and ignored the phrase gross sales price received. And before I get into the substance of what the court did, I just want to give a high altitude general summary of every royalty clause, because every clause essentially has three components. Number one, there's the royalty fraction, 15.4%, 18%, 12.5. Pretty easy to identify. The second component is what one court referred to as the yardstick. And this is how we source the royalty. Where is it going to come from? What is it based on? And the yardstick has typically two components. Either it's a market value or it's a proceeds value. When it's a market value, we look at two things, either comparable sales or the court uses the driller uses the netback method to arrive at a wellhead value. That's, again, we're under the second component of every royalty clause is known as the yardstick. And you have two yardsticks, market value or proceeds. And so in the third component is where we measure the yardstick. And there are two locations, either at the wellhead or at the point of sale. Typically, when the yardstick is based on proceeds, the measuring location is at the point of sale. They kind of go hand in hand. And in the absence of an express location in an oil and gas lease, when you have using the second yardstick, a proceeds, it's automatically assumed you are measuring it at the point of sale. When the measuring location is identified at the wellhead, that's typically associated with a yardstick that is based on market value, either comparable sales or netting out costs between the wellhead and the downstream point of sale. Here, for whatever reason, the drafter of this royalty clause utilized the second yardstick. It was a proceeds source. That's how we're going to source the royalty. It's going to be based on the gross sales price received. But then at the end, they interposed this location at the wellhead. And there have been cases in Texas that have expressly said, when you use a proceeds yardstick, but you're measuring it at the wellhead, those are inconsistent. It automatically creates an ambiguity because they're not compatible. We're talking about two different parts that just don't go together. Next slide. On May 11th, the Western District granted Chevron's motion. And Brendan and I were both surprised, shocked, and dismayed by this decision. The court never addresses the inherent ambiguity that's present in this royalty clause. You can't have a proceeds yardstick and in the same sentence, have a measuring location be at the wellhead. They're completely at odds. And one thing this case illuminates is how important it is when we're negotiating a lease or if we're litigating a royalty clause, correctly identifying the royalty valuation point. And here, because we had a proceeds yardstick, but we had a valuation point at the wellhead, that was an ambiguity that created a factual issue that should have precluded the granting of a motion to dismiss. You know, a motion to dismiss under 12b-6 is when there is no way in the world the plaintiff can prevail, and as a matter of law, the defendant wins. Well, here, if the court would appeal back the various layers of royalty litigation and really took a in-depth analysis of a royalty clause and the different components that we've been talking about, there's no way the court could have granted the motion to dismiss. There should have been a factual record created as to what the parties intended. You know, who drafted this clause? What was meant by adding that at the wellhead language at the end? You know, typically when you have litigation involving a contract, parole evidence is not admissible unless there is an ambiguity. And the court can admit and consider oral testimony as what the parties intended in order to resolve the ambiguity. Here, the judge refused to acknowledge there was an ambiguity by blindly accepting the application of Kilmer. We, again, respectfully think this was clear error. You know, Kilmer is not a case that automatically applies to each and every oil and gas lease and every piece of royalty litigation. You have to look at the lease language itself and look at the three components of the royalty clause to ascertain the source of the royalty, market value or proceeds, and number two, where are we going to measure in value that yardstick, at the wellhead or at the point of sale? Unfortunately, the court did not engage in that analysis, and we believe improperly granted the motion to dismiss. Hopefully this matter will be corrected on appeal, but again, landowners should be wary about royalty valuation point and how the royalty clause identifies where and how it will be paid. We're getting short on time. Going to briefly talk about the last case, which is a case from North Dakota, Blassie versus Bruin E&P Operating. Again, not a case that's precedential or binding here in Pennsylvania, but again, I think it's a case that was perhaps incorrectly decided and is contrary to the trend that Brendan and I have seen recently here in Pennsylvania about marketable product and where the gas is marketable. At issue in Blassie, very briefly, was a royalty clause, which we see a lot of, that said the royalty was to be free of cost into the pipeline to which lessee may connect wells on said land. The landowner argued that the phrase free of cost prohibited deduction of any post-production costs prior to the gas reaching the sales pipeline. In other words, the landowner viewed this language in the pipeline to mean the interstate pipeline network, where the gas, or actually in these cases, the oil, where the oil was actually being sold, not the first pipeline that's connected to the well, some small flow line, a commercial pipeline. Conversely, the driller argued that the term pipeline meant the first well, or that the first pipeline connected to the well, the flow line. And since the flow line connects to the well at the wellhead, this established a de facto royalty valuation point at the wellhead. And what we just talked about in coastal resources, when you have a location where you measure the well, the yardstick at the wellhead, you know, that invites the netback method, and costs that are incurred downstream of the wellhead are theoretically deductible. Next slide. The Supreme Court agreed with the driller and said that the phrase, free of cost into the pipeline represented a royalty valuation point at the wellhead. It relied heavily on a Texas case from a couple of years ago, Burlington, that reached the same conclusion. Burlington has been criticized on some grounds and applauded on others as reading too much into this free of cost into the pipeline language. You know, that language has been around for many years, and it developed when gas was typically sold, oil or gas, was sold at the wellhead. And it has continued to exist in modern leases, even though it was drafted at a time when oil and gas was always sold at the well as opposed to being moved downstream and sold at a more remote location. So that has to be taken in context when we look at this language. And again, just like coastal resources, I think there was an ambiguity in this royalty clause. And in fact, the dissent at the North Dakota Supreme Court wrote persuasively, and I think convincingly, that this case should not have been decided on summary judgment, and that there should have been a more, that the factual record should have been developed more sufficiently with respect to what did the parties intend, who drafted this clause, and what pipeline did the parties intend to be the measuring location, the flow line at the wellhead or the sales pipeline further downstream. That was not apparent from the four corners of the lease, and there was an inadequate factual record, according to the dissent, to make a decision on that. And I agree with the dissent. This was an ambiguity, and again, when there's an ambiguity in a royalty clause or any writing for that matter, the court can and should accept oral testimony to explain what the heck the parties meant when they drafted this and resulted in the ambiguous language. Here, unfortunately, the Supreme Court did not hold that a factual record was necessary, and instead said, as a matter of law, this language resulted in the netback method being appropriate and all costs incurred downstream from the wellhead being deductible. Again, I think it was incorrectly decided, but it's from North Dakota, not Pennsylvania. But it illuminates again how we have to be careful when drafting a royalty clause to be precise and specific about the royalty valuation point. Here, the parties didn't. There was some ambiguity, and the ambiguity ultimately was found in favor of the driller. We're getting pretty short on time. If there are any questions, comments about anything we discussed tonight, please reach out to us. We'd be happy to discuss further. And if you'd like a copy of the presentation, we'd also be happy to send that to you. So I hope everybody enjoys their summer and hope to see everyone soon when we do our next seminar, hopefully in person sometime this fall. Thank you, everyone. Have a good evening.